Welcome to the Spot On Insurance podcast, brought to you by Insurance Licensing Services of America, ILSA. This is Ted Tavares.
And this is Arlene Tavares coming to you from gorgeous Puerto Rico. Today, we'll be inviting our ILSA experts to share their knowledge.
But before we get started, don't forget to click on the subscribe button so you don't miss a single episode. And now here's our host, Doug Foresta.
Hello and welcome to Spot On Insurance. This is your host, Doug Foresta. Today with me is ILSA's own Joyce King. Let me say a little bit about Joyce and I'll bring her right on. Joyce has over 10 years experience in insurance licensing and compliance. She supervises the ILSA compliance project coordinator, sales team, and new client services staff. And today what we're going to be talking about is licensing and compliance issues as they relate to mergers and acquisitions. Joyce, thank you so much for joining me.
Well, you're very welcome. Thank you, Doug.
Thank you. So let's start with you and I had chatted a little bit, before the interview. And one of the things that you talked about is that oftentimes with mergers and acquisitions, would it be fair to say that maybe licensing compliance isn't always at the forefront of what people are thinking about before merger and acquisition? Would that be fair to say?
Absolutely fair to say. Probably not even close to the forefront of what they're thinking about.
So then let me ask you a follow-up question to that, which is, can you explain to listeners, why it is, before we even go through what to do prior and during and after, why is it important that we should be thinking about that?
Basically, I would say, it's always good to know if you're the purchaser, what you're about to buy, what you're about to get into, or if it's a seller, what you're selling and how good or maybe even bad you are as compliance goes. These points you can take with you to the negotiation table. So that's pretty important to have. It's a little bit of extra armor when you get ready to go into those negotiations.
So let's talk about some of these things that, like I said, we'll start with before the process. What are some of the things that we should be thinking about before a merger and acquisition?
From the beginning, if you are certainly the purchaser, you want to look at the entity to be purchased. Take a look at their licensing. What kind of licenses do they hold? What kind of licenses do you hold? Do you already match? Are you missing some licenses? Do they hold licenses they don't need? You of course could compare that to the book of business that you're going to take on. Aside from those licenses, you want to look at their Secretary of State registrations. Are they in compliance? Some of that information you can find from Dun & Bradstreet. And I know a lot of people do pull those D&B reports as they're getting ready to go in and negotiate, but they're beyond just the active or inactive. You want to go ahead and take a deeper look. If they're not in compliance, if they're don't have a good registration in that state, well, just how far are they behind? As a side thought, as an example, if an entity is in bad standing, let's say in the state of California, and they have been for several years, in order to get them reinstated in that state, not only do they have to file maybe a reinstatement, but also some back-owed returns, and those are $800 a piece. So,
Wow.
You want to factor in how many years, what's the cost per year to regain compliance in those states. Beyond Secretary of State, Department of Insurance licensing, you need to look a little bit deeper, go into the Department of Revenue reviews. Those are a little bit harder to get information on. Sometimes you may have to file a limited power of attorney, submit that to the Department of Revenue before they'll release any information. But you can also find a wealth of information there that's going to tell you a little bit more about back-owed corporate and franchise tax returns, if there are any. The last point that I would hit on, Doug, is take a look at the designated producer and any of the affiliated producers that are with the entity to be purchased. Are they going away? Are they moving? Are they coming with the business? Are they going to move into the new entity? How many people are you looking at possibly affiliating to the new entity? Of course, there's extra cost there with those affiliations, certainly state fees. The designated responsible producer, I'll talk a little bit more about the designated responsible producer a little bit later, but is it someone that's already been with your firm, or is it one of the newer individuals coming over? You want to look at what is their level of commitment, certainly when you're getting ready to hit such an expense to affiliate them as the DRLP of the new agency.
Now, I know one of the things, obviously, I know, Joyce, that this is something that you're involved with all the time at ILSA. Do you have some examples or a story for us about, companies, looking at mergers and acquisitions and maybe, related to some of these points that you've made about, looking for these things prior to the merger acquisition, or what happens afterwards?
Sure. I can actually think of one client that came to us just a couple of years ago, and they did the right thing. They did go ahead and reach out to us and said, we are interested in purchasing XYZ agency, and we just kind of want to know what shape they're in. And by the time we got to the end of that audit, that research study for them, they actually backed out of the deal. It looked like there was just going to be a lot more expense tied to, regaining compliance than it just was not going to be a very lucrative deal for them. So they kind of backed away politely. So
had they not done that work, there's a chance that they would have went ahead with the merger acquisition and ended up with, I imagine, would have ended up with a deal that was not probably what they thought it would be.
Quite possibly.
Yeah. Wow. Well, once we get to, those are some of the things to think about prior to merger acquisition. And then, I know we're talking about compliance and licensing as it relates to mergers and acquisitions. Can you say a little bit about, I know one of the things you talk about is factoring cost, the cost of compliance as it relates to the outcome of the purchase. So can you give us, can you go through some of those points about what we should be looking at in terms of those costs of compliance?
Yes, definitely. And not only cost, but the time factor as well. Let's say that, a couple of entities you're looking at merging, but we're going to spin up a whole new entity and form sort of an amalgamated entity as the result of the merger. Now you may have two entities that need to essentially go away. They're not going to survive at the end of the deal. You've got a brand new entity, but one thing that, that I always try to make clear to everyone right away is licenses are not transferable. Insurance licenses at the Department of Insurance are tied to federal tax ID numbers. So if you're going to spin up a new entity, which is obviously going to have a brand new tax ID, you can go into that knowing you're going to have to get brand new licenses. They're going to have effective dates, obviously, in current time. Nothing's going to backdate. You can't backdate any licenses to previous years, even though the entities merging out may have been licensed for years and years. So, and on that front, as far as getting the new licenses, very possible you have to get your SOS registration first, your Secretary of State registration. That could be time consuming. You may have to get an individual designated producer license before you can get the agency license. And then, heaven forbid, we've got anybody with the background questions, sanctions, criminal history, administrative actions, because that's guaranteed to just go to legal review right off the bat. So, not definitely cost is a factor, but, time too. So if they're looking at spinning up something, relatively quickly, you do have to factor in all of the what ifs. What has to be done first? Look at it consecutively. What do we need to do first, second, third? About how much time are we looking at to pull all of these triggers before, finally we have this entity spun up and ready to go.
That is a really good point. Have you seen that, working with companies in terms of they might have one timeline in their minds about how things are going to happen, and then having to actually go through with them the reality maybe of what's really entails?
Oh, definitely. As a matter of fact, I had a prospect call yesterday, and they needed some agency and individual licensing and some such licensing very quickly in the state of California. And I said, well, I can tell you right now, it's not going to come up that fast. And, okay, 3-4 weeks. No. We're looking at least a couple of months, probably, because you've got to get your individual licensed for property and casualty, your agency license. Then we're going to move into the surplus lines licensing. And there are just so many triggers that have to be pulled. And in most states, it is a consecutive and not a concurrent process. So unfortunately, they were a little bit shocked on the timeline, but it allowed them, the conversation was good, and they said, well, let me go back to my drawing board and see what I need to do.
So can you talk a little bit about asset purchase only and what that would entail?
Sure. Sure. The asset purchase, of course, is typically where in most cases, you're just buying the book of business. You're really not buying the liabilities. You don't have to factor the cost so much of the compliance of the licenses, the renewals, et cetera, et cetera. But the seller would have to absorb any cost there if the ultimate intent is to wind down that entity after the book of business was sold. So that's where I said in the beginning, you're not only your buyer, but your seller needs to be armed with what kind of cost am I going to look at after this is all said and done. So, so if the purchaser is not going to be responsible for canceling licenses and withdrawing SOS registrations and Department of Revenue registrations, your seller certainly is going to have to factor that in somewhere. That really kind of speaks to merged out entities, which is something that I'll cover just a little bit later. I do want to talk a little bit more in detail about those withdrawals and the license cancellations. One other thing that you want to factor in the cost, factor in the time. Do you need it? Do you don't need it? But that's name familiarity. How important is the name to you? So what I'm getting at are DBA filings.
Yes.
We have one client that they call at least once a month. Hey, we just purchased another entity. It's probably not that often, really, but at least every other month they're doing that. They call us quite often and say, "Hey, we just bought up another entity. Go ahead and do what you do," and we know what to do. We've done it for them from day one since the first one that they purchased. But that is we do what I talked about earlier. Where is the old entity licensed? Where is our client currently licensed? If there are any gaps, if there's anything missing, first we need to get our client licensed in those states. We come right behind that with DBA filings. You have to start in their domicile state, their domicile SOS registration. You've got to get that DBA on file with the Secretary of State, really before you can do anything else. That's before you can file DBA filings with other Secretary of State offices, and in some cases, even the Department of Insurance. Typically, the Department of Insurance is it's pretty easy to go ahead and file a DBA, but a lot of them say, I want to see that DBA filed with the Secretary of State first. So I am about to go down a rabbit trail here, but stay with me, Doug.
Sure, absolutely.
So let's take, for example, a client that in the beginning they said, well, I didn't need a Secretary of State registration to get my agency insurance license. I absolutely just don't want to have it. The Department of Insurance has not forced that on me. Even against our, we're pretty much going to advise if you're selling, soliciting, negotiating, receiving commissions, you need to be licensed and registered. The entity really does need both if you want to not have any compliance fault whatsoever. So let's say we have someone that says, nope, not going to register with the Secretary of State, just don't want to do it. Well, a few years later now, they've got a DBA they need to file. Okay, we're going to try to file that for them at the Department of Insurance. However, it happens to be a state that requires to see it at the Secretary of State level first, and not just the domicile Secretary of State. They want to see it at their Secretary of State. Well, now we've got a whole new problem, because not only do you have a DBA filing that needs to happen, now we've got to go in and register you for the first time with the Secretary of State, and hope they don't ask the question, have you already been doing business here?
Right, exactly.
Yeah.
We did a whole episode about that, because that could lead to fines, right? That can lead to problems.
Absolutely. Oh, yeah. Yes, definitely. We've seen them for new clients coming to us saying, help me, please, walking in the door with these $10,000 fines from the Secretary of State or more, or even a little less. But I know that sounds extravagant, but I've actually seen it for doing business in their state and not being registered. So, that's one rabbit trail I won't completely go down today, because like you said, we've already done an episode on that. We could do 3 more episodes just on that alone.
I bet.
But as respects to the DBA filings, there would be some cases where you would have to file it at the Secretary of State first before you're going to be able to file it at the Department of Insurance. And then just a little side tag on that, some Secretary of State offices require you to file it at the county level too. So, there's a little bit more cost to factor in. We have seen at the county level, it's as expensive, if not more, in a lot of cases to file those DBAs at the county than it even is with the state. So you want to just keep all of that in mind when it comes to DBA filings. But, like I said, that comes down to how important is that name familiarity to you and your business and your market strategy.
Spot on Insurance is sponsored by ILSA, Insurance Licensing Services of America, America's premier licensing and regulatory compliance experts. To learn more about ILSA and the services they provide, visit ilsainc.com. Let's talk about next about bringing on new faces or individuals during the merger and some of the compliance and licensing issues that would come up with that. Can you share some of that with us?
Sure. Yeah, I spoke on that just a little bit earlier. This is the designated producers and the affiliated producers. Who's going to move into the new entity? Who needs to be affiliated? You can really kind of get off in the weeds just on this subject alone. Let's say that you've got two entities merging. The one entity, maybe the designated producer of that entity had some criminal history just 20, 30 years ago, or they have some admin actions. Now you've merged, you're going to have one, quite possibly two designated producers as you are affiliating that new designated responsible producer to your entity. Just keep in mind, they're going to be answering yes to their own questions, to their own licensing questions, and therefore now, if they're the designated producer, some states require the DP to also be an officer of the company. If you're an officer of that agency, then when your agency answers the questions for new licensing, they're going to quite possibly have some yes questions as well. There's another rabbit trail. I think we've done a podcast on the admin actions as well, Doug. So I won't talk too much on that. But it could be a cost factor for sure. With your affiliated producers, it's just a matter of now you've got to affiliate them to the surviving entity licenses or the new entity licenses. And probably, it wouldn't be a bad idea to terminate their affiliation to the old entity. It really kind of depends on what's happening to the old entity. Again, I said I would speak on that a little bit later when we get into license cancellations and terminations of affiliations. I can get a little bit deeper on that. If you've got people, kind of conglomerating from a few different entities, and now we've got a new entity or a merged entity that has a new set of officers, there's another compliance requirement. You have to report your directors and officer changes to the departments of insurance. I think there's about 30, if not maybe 35, that require those particular updates, and it's typically within about 30 days of the change. So you don't have a huge window to get those reports in. You want to let them know who your new designated producers are, as well as your directors and your officers. So, Doug, as it relates to the designated producers, this is, of course, cost, time. We've gone over that. Level of commitment is so important. I'm going to tell a story about a client that we had here that came through ILSA. They came to us. They had just merged. They had a brand new designated producer. He was gung ho. He was named an officer. He was a VP of the company. He was going to just take over and be their designated responsible producer and be responsible for all those entity licenses. We made all those changes. It was a little costly for the client to make all those changes. We had to terminate the old DP and bring this new DP and get him affiliated across the board. And it was about 3 months later, he kind of said, "Nope, not having it. I'm done. I don't like the way this is working out. I don't like all of this responsibility. I don't agree with some of the things that are going on." And he left, and no notice, gone. Well, there's a time clock that starts right then. If you lose a designated producer, once the states are notified, and you should notify them very quickly, you've got 30 days to find a replacement in most states. Now, not every state
not a lot of time.
Yeah. It is definitely not a lot of time. Not every state has all the exact same state rules across the board, but most states follow that timeline on your designated responsible producer because they want to know who is the responsible party for these entity licenses. So, maybe you think it's okay. Okay, well, we'll just keep this under our hat and we won't report that the one is gone until we have another one ready to go. Okay, nothing's stopping that designated producer from making that report themselves. And that's exactly what happened to this client that I'm talking about.
Because they didn't want the responsibility, so they went off and just made sure. Yeah.
They did, and it's not the process, but what he did was he just created his own letterhead, and he sent a letter to every state that said, just FYI, I'm not there anymore. They don't have a DP because I am not it. And this really left the client holding the bag. By the time, the client came to us and said, oh, look what our DP did to us. Not only is he left, he also has notified some states, which we were starting to dig in at that point, as well. 30 days, like you said, is not a long time. They did lose some licenses as a result because they were not able to come up with a replacement designated producer very quickly. That replacement designated producer, there's probably 10, 12 states out there that says that person must also be an officer of your agency. So you've got a couple of different things that have to happen at that point. You've got to submit that director and officer update first, just so you can turn around and make them the designated producer. So, anyway, like I said, that left our client kind of holding the bag. That was not a good situation. So, if you're looking at merging entities or bringing on new responsible producers, make sure there's some kind of level of commitment there from that person. Maybe you can, have them sign some kind of, 1 year minimum contract, to stay and to hold that role. I don't know, but definitely give that a lot of thought. You don't want to spend that kind of money and have them run out on you, and you're going to do it all over again.
I know the last one under this section we're going to talk about is appointments. Can you say a little bit about that?
Sure. What you want to think about there is, certainly if you're buying a book of business, obviously the entity being purchased has carrier contracts with certain carriers. If you don't have those carrier contracts in place with those carriers, you're going to have to get on that pretty quick. So, at renewal time, you can go ahead and, roll that up under the new entity or the resulting entity. Also, if you have appointments with appointments and carrier contracts with some carriers, those individuals that you're moving over now from the older entity or the merged out entity, they're going to need to be appointed to your carrier. So not so much a matter of cost as that could be a matter of time. You just want to get right on that as soon as you can.
Well, you've given us great stuff to think about in terms of, what we need to be thinking about before merger and acquisition, during. Let's talk about how to deal with the old unused entity. So now that, the merger and acquisition maybe is through, what are some of the license and compliance issues that we now have to think about?
Regardless of whether the cost for this is going to fall on the seller or the buyer, something has to be done with the entity that's no longer going to be used. And it's not as easy as just walking away and saying, okay, well, we're not going to use that one anymore. The states don't know that. As far as they're concerned, it's still an active entity. Let's say, for example, that they're licensed not only maybe for property and casualty, but also for surplus lines. You've got to get in there and cancel those licenses to stop the reporting requirements. If you don't cancel or surrender the licenses, the SLAs, the Departments of Insurance, as far as they know, it's still an active license. You're still potentially out there doing business, and they want to see your reports, whether it's zero reports or business reports. But if you begin missing the reports, here come the fines, here come the penalties, here come administrative actions. Nobody wants to close their business or shut down the business on such a terrible note. Whether you're retiring and maybe you'll never re-enter insurance ever again, leave it with some dignity. Close down the entity the way that you should. Now, there's a good bit of cost, factored in there. You do have to surrender some licenses. Not a whole lot of state fees involved there, but, definitely you've got to let those states know that you want to, politely surrender your licenses. On the, the other side, the flip side of the coin, then you've got your Secretary of State registrations, the Department of Revenue registrations, all of that stuff. You want to try to withdraw appropriately and not just let them revoke or forfeit. So this is what we call Secretary of State withdrawals. So there is a process. There are forms. Every state has their own separate process. Some involve you having to go to the Departments of Revenue to get tax clearances. That's a different process. Some of that I alluded earlier to limited power of attorneys. You may have to file a few of those to get your tax clearances and file your final returns with the Departments of Revenue. But once you have the tax clearances, you could come back to the Secretary of State and complete that withdrawal process there. You always want to wait and save your domicile state for last. With regard to license cancellations at the Department of Insurance, save that resident state for last. Get everything else appropriately surrendered, appropriately withdrawn. Do your domicile state and your resident state absolutely last. If that involves you having to go through one more renewal period and expense a little bit more to renew that license, I would do it. Because once you kill the resident license, everything else is going to fall away, but it's not in what you would consider a good standing. So you want to try to take those steps to do everything as appropriate as you can.
You know, you've given us such great things to think about. Of course, my guest today has been Joyce King from ILSA. We're talking about merger, license and compliance issues related to mergers and acquisitions. Let's give our listeners an opportunity to connect with you. So if people listening to this and saying, boy, you know what, I really could use some help with this, what's the best way for them to get in touch with you?
You can get in touch with me. I have a direct line to my desk, area code 254-729-6127. I'm happy to speak with anybody. My email address, j.king@ilsainc.com. And feel free anytime, visit us at www.ilsainc.com.
Joyce King, thank you so much for joining me and sharing such important need-to-know information with us.
Thanks so much for having me today, Doug.
Thank you.
By the way, our show notes and bonus resources can be found on spotoninsurance.com. Subscribe now so you don't miss a single episode.
Thanks for joining us.